The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, Ms. Hoffman, when you're ready, we'd be happy to hear from you.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court. Any reasonable person would understand that when a police cruiser blocks a car into its parking space, the passengers, driver, and car are seized. But such a seizure requires reasonable suspicion, and Black and Curry have both explained that presence in a high crime area is insufficient to justify a seizure. Yet that is what occurred here. Only when officers escalated their unlawful seizure by approaching the vehicle did they see a passenger concealing a firearm. But Black prohibits the application of reasonable suspicion merely by association or geography. And Black also prohibits...
Excuse me, you said that this merely being in a high crime area won't suffice to establish reasonable suspicion. And of course, that's correct, although Wardlaw, the Supreme Court seems to suggest might be otherwise. But don't we have more here than simply a general high crime area? Because this wasn't generally a high crime area. There had been a number of drug arrests made at this very lot, at this very parking lot. So,
Your Honor, excuse me.
Why wouldn't that be something more than a generalized high crime area?
Because, Your Honor, I think in this particular instance, the cases that were cited by the government, all in which there were other circumstances, all included officers responding to a specific call. And in this particular case, there was no specific call. It was a routine patrol, and the officers really indicated that they mostly responded to loitering concerns on behalf of the motel owners. In this particular instance, the officers drove past the car, saw nothing suspicious other than people sitting in the car, and it was only because it was a high crime area that they were even present in the first instance. And Black and Curry both reject the assumption that predictive policing, like, for example, because there had been crime there before, it must mean there will be crime there again, should be rejected because it is race-based and inappropriate under the Fourth Amendment.
Well, the car wasn't just sitting there, was it? I mean, the motor was running, the headlights were on.
Correct, Your Honor.
The driver was running in for some kind of reason, but it wasn't just a car sitting there, was it?
The car was running, Your Honor, and the lights were on, which tend to indicate that the driver had run in for a quick purpose, which happened to be a lawful purpose of visiting his girlfriend. It was a long residence motel, or an extended stay hotel, excuse me, and Mr. Cloud's girlfriend was residing there, and he had lawfully entered the premises for that purpose. The officers did not see Mr. Cloud go into the motel. When they drove by, all they saw were individuals sitting in the car, which is not unlawful, and which they admitted was not unlawful.
What's wrong with approaching the...
Even if we assume, for instance, that Mr. Cloud had been sitting in the car when the police came up, and that he stayed in the car so that there might be a seizure, that's not what happened in this case. Because in order for the seizure to be effectuated, there has to be acquiescence by the defendant to the seizure. And I've watched this tape a number of times, and it doesn't look like to me Mr. Cloud acquiesced to much of anything. He got in the car, he got out of the car, he walked around. Officers asked him to come back. He kept going. He ignored their instructions. He seemed to do pretty much what he wanted to do. So I'm having difficulty seeing how this gets beyond an attempted seizure because there was no acquiescence by Mr. Cloud to it.
Your Honor, I think I have several points there. I think first, our position is that as soon as officers blocked the car was seized. And so when Mr. Cloud exited the motel room, he was seized. This court's authority in Jones and Stover both indicate that when a car is blocked, that is a higher escalation of seizure. And this court in Jones cited multiple circuits, including the 6th and the 9th, that have been in accord that when there is a car...
but he still has to acquiesce. And it's just hard watching the video to see where that ever happened.
Well, Your Honor, I think that our point is that he was seized before any of those other actions occurred. And what happened after Mr. Cloud was seized is irrelevant to the inquiry. But in any event, our position is also that when Mr. Cloud left the motel, Officer Jenkins told him or asked him if he was staying there. Mr. Cloud responded. He asked him how he was doing. Mr. Cloud responded. When he did get out of the car, we believe that at that point, when he gets into the car, he's asking increasingly incriminating questions, and the presence of officers has now escalated to the point where there are 6 uniformed armed officers and at least 2 to 3 patrol cars present, and Mr. Cloud was seized at that point. Anything that happens after he gets out of the car doesn't matter. But even if this court were to consider what his actions
what was wrong with approaching the car with a flashlight, which is essentially what they did?
Your Honor, I think that in this case, it's distinct from other instances in which there's a police-citizen encounter. A police-citizen encounter is one in which the officers approach the person and the person can terminate the encounter or not. But here, the fact that the officers blocked the car without knowing whether there was any reasonable suspicion escalated it from merely a police-citizen encounter to an immediate seizure. And in this particular case, the officers did not have the necessary reasonable suspicion to escalate to a seizure. And that included approaching...
We had a judge drop off. Can I pause everything for a moment?
Yes.
Thank you.
You give Ms. Hoffman some more time. I missed, after I asked her a question, I dropped off, so I missed all of her answer.
Sure.
Your Honor, could you remind me of which question it was that you dropped off, and I can go back and try to answer it?
Well, I had asked you about the acquiescence of Mr. Cloud, and you were starting to give your answer to why he would have acquiesced, I assume. But I could see you talking, but I couldn't hear you, so I lost at least a minute.
Okay. I will try to answer again, Your Honor. In this particular case, Mr. Cloud passively acquiesced to police authority in several ways. I also have watched the videos on multiple occasions, and as this case law makes clear, that it's when there's an ambiguity as to whether or not someone passively acquiesces, the court must look to the totality of the circumstances to determine whether or not someone was seized. And here, Mr. Cloud left his hotel room. He answered questions by Mr. Officer Jenkins, including how he was doing, why he was staying, or why he was present at the hotel. He did get into the car, but he didn't leave because he was locked in and unable to leave. And then the officers began to
Ms.
ask
Hoffman,
him,
can I stop you there? So let's assume for the moment we don't agree with you that Mr. Cloud was seized when the police blocked the car because he wasn't physically in the car at the time. And he wasn't seized while he was outside of the car because, as Judge Agee suggested, he was pretty much doing whatever he wanted. When he got back into the car, I suppose that's when he would have had the opportunity to leave the scene, but for the fact that the car, as you point out, was blocked by the police cruiser. But by then, as I understand the record, the officer had seen something in the back of the vehicle, the teenager trying to hide something under the car that gave him some suspicion as to criminal activity being afoot. So why wouldn't that be enough then at that point, if we don't agree with you as to the seizure, that the officers were entitled to continue their investigation, including holding Cloud until they resolved the issue as to what had been hidden by the passenger in the car?
Your Honor, I think there are two responses to that. First, Mr. Cloud, when he did get into the car, we agree that by that time the officer had what we believe unlawfully escalated the initial seizure of the car by approaching it and seeing the passenger concealing the firearm. But here, as opposed to many other cases in which the court determines that they can continue or need to continue an investigatory detention, in this instance, the police officers knew who had committed the crime, and they knew it was not Mr. Cloud. They had seen the passenger conceal the firearm, and Mr. Cloud was not present when that happened. And so Black makes very clear, this court's authority, that mere presence or association with someone who may have been involved in criminal activity cannot be imputed to another person at the scene. And
does it matter, Ms. Hoffman, that at some point in the investigation, Mr. Cloud admitted that the car belonged to his mother and that he was in lawful possession of the car? Does that somehow give the officers the right to investigate, given that a firearm was found in a car that was in the possession of Mr. Cloud at the time?
No, Your Honor, I don't think that it does. Even under North Carolina law, concealment of a firearm requires willful and intentional or knowing mental state. And in this particular instance, there was no indication that Mr. Cloud had any knowledge that the passenger had concealed the firearm for several reasons. First, the Officer Jenkins admitted at the evidentiary hearing that he was able to see Mr. Cloud's hands the entire time that he was in the car. But second, the officers had no information about how long Mr. Cloud had been in the hotel, whether or not even the passenger had entered the car sometime after Mr. Cloud went into the hotel, or perhaps even the passenger obtained the firearm after Mr. Cloud was in the hotel. There was no reasonable suspicion as to Mr. Cloud, other than the fact that the officer saw the passenger concealing a firearm. And under Black's authority, that is not enough in this circuit to associate Mr. Cloud with reasonable suspicion to seize him.
Well, you say he was disassociated from all of this, but on the other hand, he was the only adult in the car.
Your Honor, excuse me.
And he was driving the car, certainly, because there was a driver's seat that was vacant when he went into the motel room. And you have this Supreme Court case called Wyoming v. Houghton that says there's very often reason to believe that there is a common enterprise between the driver and the passenger, and they seem to be there sort of in it together, or at least the officers could surmise that they were. And and even if they were not, when they saw the weapon put under the driver's seat, surely they are afforded a certain latitude in trying to investigate what's up. I mean, this is not a situation where they're responding to an anonymous report or an informant, someone that refuses to give the name. This is a situation where there is direct observation of criminal activity. And where you have direct observation of criminal activity as opposed to some sketchy informant's report, aren't officers entitled to look into a situation after they directly observe a criminal act?
Your Honor, I think I have several points that I'd like to address in that compound question. The first is that the officers did not know that the men in the car were juveniles until long after Mr. Cloud was seized, when they ordered the passengers out of the car. And so the fact that Mr. Cloud happened to be the only adult was not known to the officers at the time and can't be used as reasonable suspicion. In terms of Your Honor's citation to Wyoming v. Houghton, first of all, that was different because that was a legitimate traffic stop, and there was reasonable suspicion of a crime being occurred because of the legitimate traffic stop. Here, however, there was no such reasonable suspicion. The only reasonable suspicion for why they approached that car was because it was in a high crime neighborhood. And under Black and Curry, that is—
But that's not correct. It's not just a high crime neighborhood. They'd made previous drug arrests on this very lot. It's not just sort of generalized assertion of a high crime neighborhood. But to me, the question is, when officers see circumstances like this and you combine them all together, which was the history of the lot plus concealing the gun right before them under the driver's seat and the rest. Why don't they, surely they're not just required to just, oh, well, wash our hands of it and walk away when they see what is apparent criminality right in front of their eyes. Can't they look into it?
Your Honor, yeah, I think that my initial response is no. In this instance, the officers should not have pulled behind the red car because they had no reasonable suspicion to block it in. They could have approached on foot and asked the passengers questions, but instead they escalated it to a seizure absent any reasonable suspicion.
Well, how were Cloud's rights violated? He's the defendant here. He wasn't even in the car
once he came out of the car, Your Honor.
Was he?
No, he wasn't. But the escalation continued from the initial unlawful seizure. But in any event, once Cloud came out, assuming that this court determines that Mr. Cloud can't object to the initial seizure, when Cloud came out and the officer saw the passenger conceal the firearm, I will agree that, assuming that this court finds that the initial seizure wasn't a seizure at the time that they blocked the car, then certainly the officers can ask questions of the passenger. But Mr. Cloud, that cannot be imputed to him when there is absolutely no information that he knew about the firearm, that he was present when the firearm was concealed.
Ms. Hoffman, can I, following up on Judge Wilkinson's question, so what you're suggesting is that at that point in time, the officers were obligated to let everybody go except for what ended up being the teenager in the back of the car. Is that your argument?
If the officer had ordered everyone out of the car, Your Honor, then yes, the officer had reasonable suspicion as to the backseat passenger and no one else. And simply also because in United States v. Black, and I see my time is up, if I may finish the question.
Yes, you may.
Thank you, Your Honor. In United States Black, this court also rejected the idea that where there is one gun, there are two. And that is what happened here. The officers assumed that because the backseat passenger had a firearm, that meant Mr. Cloud must have had one as well. And that is not appropriate, and it is not something that this court has accepted. And it's clearly—
Counsel, what do you base that on?
On which? I'm sorry, Your Honor.
Why do you say that they thought there were two guns?
Your Honor, I think that they've assumed, and if you go back and watch the video, when they found the gun in the back seat, they said, "We've got them." And they ran and tried to find Mr. Cloud, or excuse me, they then proceeded to try to arrest Mr. Cloud under the assumption that he had somehow participated in criminal activity. And there simply isn't evidence of that here.
Well, they may have been detaining him, but I don't see a basis in the record for you to use this one gun, two gun presumption.
Your Honor, I'd have to look at my sites again, and I can try to find it for you. But my recollection of the record was that they had testified at the evidentiary hearing was they didn't know if Mr. Cloud was armed as well. And it's on that basis that I made that argument.
My problem, I keep coming back to the basic point that where officers see a criminal act unfolding before their very eyes, that what they have to do is walk away, either one, just leave, or number two, look at only one occupant of the car, when, as I come back to Wyoming v. Houghton, suggests that there's an association, to put it mildly, between people, and I just don't understand why, as a matter of common sense, they can't look into something further. They didn't use unreasonable force against anyone. They patted somebody down, they frisked, but obviously they frisked because there was a gun, and all they want to do is just find out what's going on. And there's a good chance that what's going on isn't legitimate, but they just wanted to learn more.
Your Honor, I'm not suggesting that once they saw the gun, they had to walk away. I think the initial problem was that they saw the gun in the first instance in how they seized the car. And I think that once they saw the firearm, absolutely, they were permitted to look into it with regard to the passenger. In Houghton, when they spoke about the common enterprise, it was because in Houghton, the officer saw a needle in the driver's pocket, and the driver admitted he used it for an unlawful purpose. Houghton doesn't stand for the principle that you can seize and search any person that happens to be at the scene. What Houghton held is that in that instance, officers may search the car and the containers within the car, not the individuals associated with the car. Houghton doesn't extend the principle that far.
All right, thank you.
Thank you, Your Honor.
I'm sorry, Judge Wilkinson, I have one additional question for Ms. Hoffman.
Absolutely, go ahead.
Thank you. So the district court in this case concluded that Mr. Cloud was not seized until he was actually tackled and taken to the ground and subdued by the officers in this case. And let's assume that that's correct. And at the time that they attempted to detain him, he resisted and fled. Do you concede that even if there might not have been enough suspicion at the time to detain Cloud, that once he fled, that additional factor is added to the mix in deciding whether or not the officers had at that point cause to seize him?
Your Honor, I don't, for two reasons. First, it's that in order for that to occur, for example, the government cited United States v. Ruffin. And in Ruffin, the reason that this court upheld the subsequent arrest and concluding that Mr. Ruffin had not acceded to authority was because the initial stop was supported by reasonable suspicion. And we're arguing here that that is not the case. Also, in this court's case, or in this court's authority in United States v. Sprinkle, the court determined that officers were had legitimate reason to arrest the defendant after the fact, only because he committed a new crime, and it was that his illegal actions were new and distinct from any crime he may have been suspected of at the time of the initial stop. And in this instance, the fact that Mr. Cloud fled was not based on a new crime such as Sprinkle, where Sprinkle aimed his gun at the officer and shot. And so in this particular case, we don't believe that the initial seizure was lawful, and therefore any subsequent attempt to again seize Mr. Cloud violated the Fourth Amendment.
All right, thank you very much. Judge Diaz, do you have further questions?
I don't. Thank you very much.
All right, Judge Agee, do you have any further questions?
No, sir.
All right, then let's hear from Mr. Enright.
Thank you, Your Honor. May it please the court, Anthony Enright for the United States. The district court properly denied Cloud's motion to suppress for a couple of reasons, but I think perhaps the most direct one is that Brendlin versus California teaches that police can detain a car solely to investigate a passenger's conduct. Officer Skipper testified unequivocally, not just that he saw something suspicious going on in that car, but that the passenger was illegally concealing a gun. He saw the butt of a gun, and he saw him conceal it under the seat. That authorized, the Fourth Amendment authorized police to detain the car and to detain all of its occupants.
Mr. Enright, but Ms. Hoffman is saying that the car was detained or seized even before the officer saw the weapon under the seat. So how do you respond to that?
I have a couple responses to that. The first, I think, perhaps the one I need to make now, is that issue is waived. That was not what the defense argued below, and the defense counsel's words were, we are arguing that Mr. Cloud was seized the moment he got into his car. And that was so it was forfeited below, and it was not the argument in the opening brief either. So I would start with that, but the perhaps easier answer is Cloud wasn't even on the scene. When you speak of the conduct needed to detain a person is intentional conduct directed at the detained individual. Mr. Cloud was entirely inside the motel at the time they pulled up, and even at the time they approached and shined the flashlight. He came out after they'd seen the gun. He certainly got. So
had he been in the car when they pulled up and blocked the car in the way that the record suggests, would that have been a seizure?
That would have been a tougher case, Your Honor. There is some testimony about. I think one of that becomes a question under the Mendenhall factors. It suggests under the Mendenhall factors, really the only Mendenhall factor at the time was really that there were police in uniform. At that moment, there were not a large number of police. They hadn't asked any questions. The car was only partially blocked. And Mr. Cloud also he put his head over his shoulder. He didn't see that it was blocked to the extent he did at all until after he was well into the car. So that is a tougher question, but I think the answer could be no. But certainly the way the facts shook down in this case, Mr. Cloud wasn't detained because he was certainly free to leave. He could have stayed in the hotel room, or he could have just walked away. He chose to put himself in the car, and he chose to put himself right in the scope of Brendlin. What Brendlin says is a reasonable person wouldn't expect that you can just come and go from the focal point of an investigation. And that's in the Brendlin case, the focal point was a car. Police have a bright line rule authority if they have reasonable suspicion of criminal activity going on in a car to detain all those occupants while they're investigating this. And this entire exchange, from the moment they walked up to the car to the time that Cloud began to flee, was about 5 minutes. And that was moments after they pulled the gun out of the car. So that was certainly within the scope of the reason for detaining the car, the reason the Fourth Amendment authorized them to detain the car. So the Fourth Amendment authorized.
So, Mr. Enright, can I ask, at the time that the officers saw what they believed to be a gun being secreted under the passenger seat, what crime, if any, did they suspect Cloud of committing?
So I don't know if there was testimony that they suspected him of a specific crime, but the standard is an objective one. And they certainly, I think, and I want to mention that this is a different point, because they didn't need to suspect Cloud of a crime in order to detain him at the scene of the car he was in. That's the bright line rule of Brendlin, and the bright line rule of Arizona versus Johnson is you do not have to have individualized suspicion of, for example, the passenger if you're stopping the driver under Brendlin, of the driver if you're stopping the passenger. So, and you have reasonable suspicion for that purpose. So I don't mean to not answer your question. What I think the police were suspecting is that he may be in a common enterprise with the other members of the car. And I think they had good reason to that. To the extent reasonable suspicion of Cloud individually is necessary. I think they absolutely had it under the objective factors they were facing, because the individual in the back seat, the officer testified, he held his gun in his hand in front of the other people in that car, including Cloud's daughter. He wouldn't have done that if he didn't trust them, especially in a high crime area. And when they pulled up behind the car, they saw everyone sort of averted their eyes and rolled up the window. It wasn't just LW who didn't want to interact with police or who was perhaps concerned about that. The police had reason to suspect that whatever was going on with LW was an enterprise involving everyone in the car. And when Cloud got in the car, as if he were the driver, as if he had driven them there, or as if he were going to drive them away, he gave them reason to suspect that whatever armed enterprise was going on in that car, he was involved in. And it's very telling, Your Honor, that LW hid that gun under the seat feverishly in response to police shining a flashlight in there. And then when they asked him about it, he said, "Oh, it's just a cigarette." In other words, he was concealing that gun. To the extent he had the right to carry a gun openly, he wasn't saying, "Oh, Your Honor, I'm just lawfully carrying this gun." He was concealing that gun from police, which is very suggestive of the fact that he was perhaps using that gun for a purpose he didn't want police to know about. In other words, illegal activity. And in a high crime area where they'd seen violent crime, drugs, gun crime in that area recently, that's certainly suggestive of the concern that these folks hanging out in a car, armed, and concealing that gun from people were engaged in criminal activity that warranted not arresting them necessarily, certainly not proof beyond a reasonable doubt, but simply investigating further. The reasonable suspicion standard is not a high bar. It's well lower than a preponderance of the evidence. It's well lower than probable cause. It's more than an inchoate hunch, just what's necessary to investigate further. And after seeing a firearm, it's a very dangerous situation, not just for the police officers, but also for the other people on the scene and the people in the motel and the people in the parking lot. That's something police really have an obligation to investigate, and to do so safely, they need to at least control the scene and detain the people who are in that car. I do want to see. Well, Your Honor, I don't want to belabor any points that I've touched on a little bit. I think I've touched on pretty much everything I wanted to say. I think those are two rationales. One is the Brendlin, Arizona versus Johnson rule, and another is reasonable suspicion. I think either one were there. I do want to note that I think Judge Wilkinson mentioned that, of course, they wanted to pat him down. They certainly had authority to pat Cloud down, because you can pat somebody down if you have reason to believe he's armed and potentially dangerous. And his close association with a gun, whether he was involved in crime or not, authorized the pat down, certainly, because the police were authorized to stop him.
Well, the whole situation, when you put it all together, is fraught with a certain amount of danger, and that's, that to me, that's important, because I think the officers had every right to protect themselves and not be shot, and they also had a right to protect other passengers in the car and to de-escalate the situation if they could. And I worry if we were to reverse Judge Cogburn here, that we would say in the face of a dangerous situation, and in the face of incriminating evidence, and in the face of a situation where it appears that the people in the car, the different people in the car, were not just disconnected, but were at least quite possibly aware of each other's activities, that the police have to sort of cease and desist, that they can't ensure their own safety, and that the only option for them is to simply throw up their hands and walk away. And I just don't think that can be right. And the implications of a position like that for law enforcement would be serious. That's just a common sense, a common sense assessment of the situation, which I guess was Judge Cogburn's too.
Absolutely, Your Honor, and that sense, which is both very consistent with common sense, but it's also well backed up by Supreme Court precedent. Maryland versus Wilson and Arizona versus Johnson both make very clear that the danger presented by an ordinary traffic stop, a circumstance where you stop someone for speeding, is not that the people in the car are going to react badly to being caught for speeding. It's that they might react violently if police discover that another crime is going on in the car when they conduct a traffic stop. Here, that risk is right in the face of police officers, because what they observed wasn't speeding. What they observed was somebody committing a gun crime in the car. The risk they faced was very real, and you can see that, I think, in real terms in Officer Jenkins's testimony and the video itself. He was very careful. He didn't want to escalate the circumstance and let everybody know he found a gun until he got everybody out of the car and detained them, and that was reasonable. That was exactly what you might expect police to do to protect their safety and to protect their safety of others, and that's all the Fourth Amendment asks, that police act reasonably.
Did you address already the question of if there was a seizure at some point, whether or not Mr. Cloud ever acquiesced to a seizure?
So I think I haven't really addressed that. I'm happy to do it now. I think I have to admit that there was a seizure at some point, which is when physical force was applied. Even if somebody doesn't acquiesce, if police officers physically restrain him, that's a seizure. I think it's certainly questionable whether he acquiesced. He clearly didn't acquiesce at any point until he was seized. He didn't. I've watched the video. Judge Cogburn watched the video, and we heard the testimony of police officers where he was ignoring commands to go hang back with other police officers. It was a lot. I know my friend disputes that he heard it, but it was a pretty loud command on the video, and the officer testified that it was ignored, and the district court was free to credit that. So I don't think he probably didn't acquiesce. I do think it's a bit of a red herring, Your Honor, because we ultimately did seize him, or police ultimately did seize him at the time when his flight started and after they seized that gun. But it's also a red herring because police had the authority to stop that car and detain him from the get-go, from the moment they saw the gun in the car and from the moment he then got in the car. And to the extent they gave him, or he had, because he didn't acquiesce or because police gave him the liberty to continue to hang around in the scene instead of ordering him to stay in the car, which they well could have done under this court's decision in Myers, which is an unpublished decision applying Arizona versus Johnson. To the extent they gave him more liberty, they certainly didn't violate his constitutional rights by doing that instead of saying you've got to stay in the car. So I don't know if that is the most efficient answer to your question, Your Honor, but I hope it addresses it. If there are no further questions,
do you have any further questions you'd like to ask?
No further questions.
Judge Diaz? Judge Diaz?
No, thank you.
Okay.
if there,
Ms. Hoffman, you have some time for rebuttal, so we'd be happy to hear from you in rebuttal.
Can you unmute yourself, Ms. Hoffman?
Yeah, I can't hear her.
I think, there we go. Can you hear me now?
Yes.
Thank you. Your Honor, just a couple of points. The government relies heavily on Brendlin and Arizona v. Johnson, and they mentioned United States v. Myers. All of those cases are different because they all involve a traffic stop. And I know that seems like semantics here, but it's not. A traffic stop is premised on the idea that someone has committed a crime or some sort of traffic violation, which provides the officer with reasonable suspicion to stop the car. And in this instance, there was no reasonable suspicion for the officers to approach that Dodge. At that point, in Brendlin, for example, the court held that they learned that the passenger had an outstanding warrant, but it was after they had already stopped the car lawfully, and we just don't have that here. Your Honor, I also wanted to address one point that I forgot to address earlier about this being a high crime area. I went back and looked at the testimony, and Officer Skipper, I believe, indicated that the task force had only made 2 prior arrests in that parking lot. This wasn't an issue where there was an arrest every night for weeks on end. This was a high crime area that was an area of predominantly African American and Latino residents that was being patrolled for predictive policing, which is, as this court has found, is not a reliable indicator of criminal activity. In terms of the pat down, Your Honor, I would note that yes, it is true that for an officer to pat down a person, they must have reasonable suspicion the person is armed is dangerous. But they only proceed to that step if they also first had indication that that person, the individualized suspicion, that person was engaged in criminal activity. And they did not have that here. They had no indication that Mr. Cloud was involved in criminal activity.
With respect to their initial approach, you have obviously, I think Mendenhall is a keystone case, but officers are not forbidden from approaching a car or an individual or whatever and asking questions. The Supreme Court has repeatedly made clear that police officers, for a great many reasons, have a perfect right to approach an individual or a group of individuals and ask questions.
Your Honor, I don't dispute that. I agree that that is what Mendenhall holds. And if the officers in this case had merely approached the car on foot and not blocked the Dodge and preventing it from leaving, they could have asked questions of the individuals in the car, and we would have been, I think, dealing with a different circumstance. But in this case, the officers immediately escalated the situation by blocking the car so that when Cloud came out, when the passengers were in the car, no one was able to leave from the very first jump. And in that particular instance, that's why this case is...
Well, but the problem is again, Cloud is the individual who is seeking suppression of the evidence. And there's a question of how Cloud's rights personally could be violated if he's nowhere in the car but is in a hotel room. I mean, that would seem to me to be a difficult case for him to make because he was not on the scene.
Your Honor, as soon as he exited that hotel room, I mean, frankly, when they blocked the car, had Cloud exited the hotel room and tried to leave, he would have been prevented from doing so. And in fact, that's actually exactly what occurred. As soon as Cloud left the hotel room, he was seized. And the officers knew who committed the crime when they did approach after they had blocked the car, and it was not Cloud. Cloud was not associated with the juveniles. The officers had no information whether or not Cloud had, whether all of them had arrived with him. We just
when it's clear that officers are looking into a matter and are investigating a matter and the rest, that he doesn't have the right to simply say, to heck with you, I'm going to get in the car and drive off. And if an investigation is ongoing or there is it reasonably appears that officers are looking into something, if they're looking into an action by a passenger in the car, the driver in the car is not privileged to saying, well, to heck with you. I'm getting in this car and drive off. Now, you see what I mean? He didn't have the right to flee, and he didn't have the right just to get in his car and saying, you can't, then saying to the officers, in effect, you can't do anything about it, I'm gone.
Your Honor, in this case, the officers are required under the Fourth Amendment to have reasonable suspicion that Cloud was engaged in criminal activity, and they did not have that here. I see my time is up. Do you have any other questions?
He wasn't, Cloud wasn't at the North Pole. He was the driver of the car.
He was the driver after. I mean, the officers didn't know if Cloud drove to the motel. There happened to be an empty driver's seat, but no, the officers don't know what happened because they did not see Cloud get in or out of the car. They didn't see how they arrived at the motel. Certainly, Cloud got into the car at one point. My opposing counsel indicated that his daughter was in the car. But again, officers saw his hands at all times and knew that Cloud was not the one that had hidden the gun under the driver's seat. They saw a crime being committed. They knew who committed that crime, and that person was not Mr. Cloud.
All right. Thank you very much, Ms. Hoffman. We certainly do appreciate your argument. And if either Judge Agee or Judge Diaz has further questions, I'd be delighted to have them ask them.
No questions.
Judge Diaz?
I don't either. Thank you very much, Ms. Hoffman.
All I want to say is I want to thank both of you for your arguments, and it's very disappointing to all of us that we don't have the opportunity to come down and greet you personally and shake your hands and say thank you for your service, not only to your clients, but to the court. But I can assure you that it's very much appreciated. And please, both of you, have a nice day.
Thank you, Your Honors.
Thank you very much, Your Honor.
All right. I'm going to ask the everybody can hear everybody else? Can the lawyers hear all of the judges?
Yes, Your Honor. Yes, Your Honor.
All right, Mr. Foster, whenever you're ready to start with the Skidmore case, we'd be pleased to hear from you.
Morning, Your Honors. May it please the court. My name is Jason Foster, and I represent Tammy Skidmore in this matter. For over 100 years, Ms. Skidmore and her predecessors in title have owned a piece of property in Kincaid, West Virginia. They look out their front porch onto Luke Creek. Behind them are woods and a hillside. In front of them is the creek. On the other side of the creek are Norfolk Southern's rail lines, and then the road that runs through Kincaid on the other side of the rail lines. So it's important to understand the geography of this case to understand the nature of why this claim is governed solely by West Virginia law, and there is no basis for federal jurisdiction in this case. All of Norfolk Southern's rail lines are on the opposite side of Luke Creek from my client's residence. There never has been any rail activity on my client's side of the property. In fact, the strip of land that brings us here today is very narrow and would not be able to support any function of the railroad whatsoever. And Norfolk Southern has introduced no evidence into the record that it ever planned to, ever did, ever can, or ever will use it for railroad operations. So again, this slice of property has been under the exclusive control of my clients and her predecessors in title for over a century. During that time, she has built a portion of her house onto the disputed property and a section of walkway, and also part of the bridge that is used to cross over onto her property. Not once has Norfolk Southern or any of its lessees ever raised an objection to this or told her, hey, you don't own this property. In full view of the entire world, she has used this property as her own. And now that Norfolk Southern has installed a drainage pipe slightly upstream from her property, that property has begun to erode away. And
is there any evidence that Norfolk Southern abandoned the property? I mean, the fact that property is not improved wouldn't necessarily mean it's abandoned.
That is true, Your Honor. However, abandonment has a special meaning in the world of the ICCTA, and that deals exclusively with the service of the rail line itself, the tracks itself. So when the ICCTA talks about abandonment of rail service, it's actually trackage, it's actually transportation. It's saying, hey, either a private party can do it, or the railroad itself can go to the Surface Transportation Board and say, hey, we want to abandon rail service on this line. We don't want to use these rails anymore. And the plaintiff in this case, or Ms. Skidmore in this case, is not saying they can't use their rail lines. And it's not even a crossing case like the Fifth Circuit was facing in Franks, which it found was not subject to ordinary preemption doctrines for a crossing. So this is not a crossing of tracks issue. This is not an abandonment of tracks issue. This is a small sliver of land that is literally eroding away, that the Norfolk Southern has never used and could never use for any of the rail purposes that are laid out under the ICCTA.
Well, I mean, that's probably a case for further factual development, but what we're dealing with here is a very preliminary question of jurisdiction, and the question is whether a claim of adverse possession, not just your claim, because as I say, the factual development is of whether adverse possession lies or whatever. That seems to me a different question from the threshold question of jurisdiction. And so I don't understand why a common law claim such as adverse possession can interfere with the operations of a railroad as much as a statute or regulation can. I mean, that's what Congress was concerned about, which was interference with railroad operations. The whole impetus for the act was that rail transportation was getting squeezed and disadvantaged by newer modes of transportation, or by highways, by trucking, by air, by shipping. And you read the background to this ICCTA, and there's a feeling that the national transportation structure has to be a varied one, and that all parts of it, not just trucking and shipping and air flights, but that railroads have an important part to play, and that regulation, whatever that means, can come through a common law cause of action simply because a common law cause of action such as this has the same ability to interfere. So that's what concerns me from the standpoint of the jurisdictional question.
Your Honor, if I may, I agree with every word that you just said, and all of those concerns regarding the uniform nature of the ICCTA are absolutely right. As a matter of fact, this court, a panel of this court in the Edwards case recently back in December addressed the issue that common law claims can fall under ICCTA preemption. However, it is important that we maintain the distinction between the doctrine of complete preemption, which creates federal jurisdiction, and the defensive doctrines of ordinary preemption, which do not. Ordinary preemption is an affirmative defense, and even though a state claim may raise the central issue of a federal defense, it does not confer federal jurisdiction. The state court here in West Virginia can apply the ordinary preemption doctrines equally as the federal courts. So the question is does the complete preemption doctrine apply in this case to provide a basis for federal jurisdiction? And the question of the defenses of ordinary preemption are reserved for later in this argument. But the threshold issue, the cart that we cannot get ahead of the horse is, does the complete preemption doctrine apply to...
I mean, I certainly understand the difference between ordinary preemption, which is in the form of a defense, an affirmative defense in state court, and complete preemption, which transfers jurisdiction to the federal courts. But with respect to the doctrine of complete preemption, Congress has charged the Surface Transportation Board with the authority to administer this statute. And I was under the view, or was questioning whether the Surface Transportation Board had taken the view that state common law claims were indeed preempted by this statute, because there were cases before the Surface Transportation Board where there were condemnation actions by local governments, and the STB held those condemnation actions to be preempted because of a loss of railroad rights at issue. And so I'm wondering whether we owe some form of Chevron deference to the STB when it looked at condemnation actions which were brought by local government. It's true, but which is different from a formal statute or reg. And I'm just wondering whether, in light of those cases, which I read, and I'm just wondering whether there's some Chevron deference owed to the Surface Transportation Board here.
Your Honor, I do not believe that Chevron deference applies in this case, because the cases that you refer to from the Surface Transportation Board apply the defensive doctrines of preemption. Now, they call it something a little bit different than what the courts do. The courts usually discuss ordinary defensive preemption and express and implied. However, the Surface Transportation Board uses different terms, categorical and as applied. They're roughly analogous, but again, those are fact dependent, and those determine whether or not a claim is preempted under ordinary preemption analysis. I was not able to locate, and Norfolk Southern has not directed my attention or the court's attention to a case in which the Surface Transportation Board has discussed the complete preemption doctrine.
Well, they wouldn't have had occasion to, I wouldn't think, because the case doesn't arise before the Surface Transportation Board after it has been removed from state court to federal court. So I'm not sure that the complete preemption doctrine doesn't arise before the agency in the sense that it would before the federal court, because the agency is not resolving questions of federal jurisdiction.
I agree, Your Honor, and that's why I believe that Chevron deference to a jurisdictional determination for subject matter jurisdiction is not appropriate in this case. However, this court's decision in Lantz v. Tharp does lay out the proper analytical framework. And in Lantz, this court has stated that state law complaints usually must stay in state court when they assert what appear to be state law claims. And the court also said that the sine qua non of a complete preemption doctrine is a pre-existing federal cause of action that can be brought in the district courts. That has to appear, that cause of action has to appear in the statute itself, and it does not in this case, Your Honor. The congressional intent that the state law be entirely displaced must be clear in the statute, and it is not. Furthermore,
Mr. Foster, can I ask you about that? So are you saying that unless there is a remedy available under the relevant federal statute that you can never have a case of complete preemption?
Not only a remedy, Your Honor, but a cause of action. The case law is clear that you have to have both a cause of action and a remedy. If you don't, there isn't federal question jurisdiction. That doesn't mean the ordinary preemption doctrines don't apply. They still do with complete force and effect. It's just a question of which court is going to be responsible for applying those doctrines.
Well, I mean, but in the Fifth Circuit case that I think you mentioned earlier that dealt with railroad track operations and switches, there was a claim of negligence per se and then simple negligence. And the Fifth Circuit indicated in that case that the claim of negligence per se was preempted, notwithstanding that there was a state court statutory remedy. And I don't think the court then went on to say that it mattered whether or not there was an alternative remedy under the federal regulations. It just said the claim was preempted, end of story. So I don't understand why you're suggesting that there has to be a remedy or else there can never be complete preemption.
Well, a couple of things, Your Honor. The case I was referring to earlier was Frank's. I believe the case you're referring to now is Elam. And Elam, the question of federal jurisdiction was not before the Fifth Circuit. And they applied ordinary preemption doctrines in that case to find that the negligence per se was preempted under ordinary preemption doctrines because the anti-blocking statute basically said how long trains could stay at crossings. And they said, in that case, the circuit said, you can't tell a train how long it has to wait on its tracks because that directly involves regulation of rail transportation. The negligence alone, in and of itself, is not subject to ordinary preemption. And the reason I keep going back to this test that the Fourth Circuit uses for complete preemption is because it appears in the case law, and the United States Supreme Court has used the doctrine very sparingly and has actually recognized it in under only 3 statutes: the National Banking Act, ERISA, and the Labor Management Relations Act. So it's a very narrow doctrine to begin with, and it's a very specific test that has to be met. In this case,
the only question I had is whether whether allowing the common law claim to proceed, how that squares with the basic purposes of the statute, because normally you have federal jurisdiction when there is a real danger of home cooking, whenever in whatever state or county the case may arise. And just as a matter of practicality, this particular claim may not seem to pose much of an interference, although I suspect it does in terms of its impact on drainage of the railroad tracks, because the railroad's interest in its route, it's not just between the rails. It doesn't, extends beyond the tracks proper. And when you have a local landowner posited against this big bad interstate enterprise like the railroad, that's a hard environment for the railroad to make its case. It just, as a matter of fact, it is, and the character of a railroad is interstate in nature, and it implicates the same sort of interest that the Constitution assigns to Congress under the commerce power. This is not an intrastate matter. It's really an interstate matter. And I think that at least part of the purpose of this ICTA was to have matters that implicate interstate commercial interest be free from home cooking kind of situations. And this is what concerns me about saying, oh, well, there's no federal jurisdiction here. I just wonder whether we really go completely against the purposes of the Act, because the ordinary preemption doctrine, which is by nature of an affirmative defense, is very different from complete preemption, because it's the setting that matters. It's the courtroom that matters. I mean, I'm a great believer in federalism and in standing up for the sovereign prerogatives of states. But the federal government also has an interest, is embodied in interstate transportation in the Commerce Clause, and I just don't want it chewed up, and I appreciate your case, and I think it's a good one. It's a serious one, but I wanted to lay bare to you what my concerns are.
Your Honor, I see that I'm over my time, and I am happy to address those concerns now, or I have some time left over.
Why don't you go ahead and address them now?
Your Honor, one case that I wanted to get to that I haven't had an opportunity yet is the PCS phosphate case from this court that was decided back in 2009. That involved private agreements between railroad companies and third parties. And in that case, the Fourth Circuit found that neither express nor implied preemption defensive doctrines applied. Of course, again, that was not a jurisdictional case. However, the court's discussion of the ICCTA in that case, I believe, goes to your concerns. And in that case, the court stated, Congress narrowly tailored the ICCTA preemption provision to displace only regulation, i.e., those state laws that may reasonably said to have the effect of managing or governing rail transportation, while permitting the continued application of laws having a more remote or incidental effect on rail transportation. So the ICCTA was not meant to displace all state laws across the board. The question and the purpose behind the ICCTA was not interference, say, with track crossings and negligence claims, because those are permitted and those are allowed to be filed in state court. but it's the direct economic regulation of rail transportation. You didn't want to have to take freight from West Virginia to California, go through 15 states and have to pay 15 different fees and get 15 different permits. So the question really is, under the ICCTA and the harms that it was trying to prevent is, are you directly trying to regulate the economic aspects of rail transportation? And the history is clear from this court's own precedent that laws that have a more remote or incidental effect are not within the scope of the ICCTA. And I lay at bed at night and sometimes think, what could be more remote or incidental?
But there's no language in the statute that says that it's confined only to economic regulation.
That's correct, Your Honor. And if you look at the express preemption portion of the statute itself, it speaks, and it's the second sentence, and it says, except as otherwise provided in this part, speaking of 49 USC 10101, the remedies provided under this part with respect to regulation of rail transportation are exclusive and preempt the remedies provided under federal or state law. So it really is economic regulation. And if you look through the entire statute, there's no pre-existing federal cause of action that deals with state property claims, just like there's no pre-existing cause of action for a breach of contract claim, which this court has already found is not subject to ordinary preemption doctrines in the PCS phosphate case.
All right, thank you very much. And you have some rebuttal time, and we'll prepare to hear from Mr. Atkin.
Thank you, Your Honor.
Before we move on, I know we're way over, but I did have one question I was trying to ask.
Yes, I'm sorry, Judge Agee. So, Mr. Foster, hold back because Judge Agee has a question for you.
Yes, sir.
I may be remembering incorrectly from the record of the briefs, but I thought I recollected that the claim that you have brought with respect to the railroad property, even though it's a common law adverse possession claim, could have been brought before the Surface Transportation Board by way of an application. Is that correct?
That was an argument that was made by counsel in response to the additional authority that I cited. Briefing was closed by the time this court decided the Edwards case in December of this year. I filed a notice of additional authorities. Defense Norfolk Southern's counsel responded, stating that this could have been brought before the Surface Transportation Board. And in that particular filing, let me pull it up here real quick. That statute deals with the abandonment of rail lines. It's not the abandonment of railroad property in general. So if you take a look at the statute itself, it is confined exclusively to the abandonment of rail lines. And I'm pulling up the site right now. It's 49 USC section 10903. And it says section A1, a rail carrier providing transportation subject to the jurisdiction of the board under this part who intends to A, abandon any part of its railroad lines, or B, discontinue the operation of all rail transportation over any part of its railroad lines. So that can be brought directly before the Surface Transportation Board, Your Honor, and that is categorically not what the state law claim in this case is trying to do. We don't want to do anything to the rail lines. We don't want to touch the operations. We're not trying to even get an easement for a crossing. We're just saying, hey, the property across the creek from you guys that you haven't used for 100 years, that you've let us use for ourselves, all we're saying is you can't just put in a pipe and let that wash away. You can't destroy our property in that way. And those property damages claims are not available to be brought before the Surface Transportation Board.
All right, thank you.
Yes, Your Honor.
Mr. Atkins, we'd be pleased to hear from you.
Thank you, Your Honors. Raymond Atkins for Norfolk Southern. I'd like to begin by answering the questions that were asked by Judge Diaz and Judge Agee, and then turn to the broader questions presented by Judge Wilkinson about the role of the railroads in interstate commerce. So let me start with Judge Diaz. Your question was whether or not there has to be a remedy under the law in order for there to be complete preemption. And then you asked about the Elam case in the Fifth Circuit. So let me just first correct the record. The Elam case is a complete preemption case. The Fifth Circuit very carefully walks through the doctrine to try to distinguish between those state law claims that might be ordinarily preempted but can't rise to the level necessary for federal question jurisdiction from those that don't. And in that case, Your Honors, there is no remedy available at the STB for a block crossing. But what the court said is it still fell within the heart of the scope of the Interstate Commerce Act, sufficient to create federal question jurisdiction, distinguishing the issue of jurisdiction from the remedy. And so then also you ask, does there have to be a remedy? The Supreme Court has addressed this question. The doctrine itself is a little opaque, but the one point that the Supreme Court has made continuously is that the remedy can be significantly different or not even exist compared to the one that's available in state law. So I would look at the Caterpillar case, Your Honor. It's an interesting case because the issue that was presented to the Supreme Court was whether this was a Labor Act type case. The question was whether the underlying state action fell within the scope of federal law. The Supreme Court ruled that it didn't, but it took the pains to correct the lower court's decision that said that there also had to be a remedy. And the Supreme Court said that's not the case. It really just needs to fall within the scope of the Interstate Commerce Act, sufficient to create federal question jurisdiction, which we submit is present here. So
can I ask a follow-up to that,
Absolutely.
Mr. Atkins? And thank you for that clarification. So in this case, did the district court conduct that analysis here? I mean, did the court actually consider whether or not there was a remedy before deciding to dismiss the case?
So it did not, Your Honor, because this claim was not presented to the district court. So when the plaintiff challenged the removal, they of course get to indicate what they think was deficient in that removal order, and they argued that there was a timing issue. And then they argued pretty strenuously that you can't have complete preemption unless you have complete preemption. Unless you preempt all forms of state regulation, then you can't have complete preemption as to this particular cause of action. So the district court did address those issues. And then they also argued that there was no ordinary preemption because the land in question wasn't really being used for rail service, which was also a question that the district court addressed. It really wasn't until the rebuttal in the briefing before this court where the issue about whether it sort of fell within the scope of the Interstate Commerce Act and how closely the remedy needs to mirror it really became a live issue. I will confess, you can find a sentence or two in the opening briefs, but the focus of the opening briefs was on the phosphate case and whether or not you completely preempt all forms of state regulation, whether that's a prerequisite for complete preemption. So let me then turn, if I may, to Judge Adji's question. I hope I pronounced that correctly, apologies, Honor, which is, well, could they have brought this type of claim to the STB? And I submit the answer to that is yes. So property owners, the states, sometimes they want to forcefully remove property from the interstate rail network. It happens occasionally, it's not done with any frequency, but since at least the 1940s, the Supreme Court has recognized that parties, property owners, can file a petition to the ICC, now the STB, to try to seek an order from them saying that this property is not necessary and force the railroads to remove it from the interstate rail network. We referenced the 10903, that is what's referred to in the literature as a adverse abandonment, where you're forcing the railroad to abandon a line. The STB has struggled. Sometimes cases don't fit smoothly into 10903. So my opponent suggests that maybe this particular piece of property might not fit smoothly in 10903. In those circumstances, though, the STB has provided an alternative path for folks to get that kind of relief from the STB. So Judge Adji, this comes up frequently when somebody wants to force a railroad to abandon something that might be in a yard or a sidetrack. Those types of facilities are expressly exempted from the requirements of 10903. So you cannot bring an adverse abandonment case if you have a problem with somebody's yard or a siding or a spur track. That is just not available under the statute. But the STB has crafted as another mechanism. And it's not really terribly surprising because the overall thrust of the Interstate Commerce Act is to have the one centralized federal regulator who's responsible for the exit and entry and exit in this space. And there is an overarching national interest in keeping these corridors intact. And so the Supreme Court, sorry, not the Supreme Court, the STB in the Giao case, which is one of the leading cases on this expressive question, looked very carefully about how problematic would it be if plaintiffs could use state adverse possession claims to chip away at the existing freight rail network. And the board concluded that that is contrary to the plain language of the statute. It's contrary to the legislative history behind the ICTA preemption provision, and it's contrary to the overarching national interest in securing these corridors. So that kind of leads us to the last question, I think, which in deciding whether there was at least, jurisdiction to hear this case for removal purposes, which is what was the property sufficiently related to rail transportation in order to trigger all of these national considerations. There's a couple of cases that we refer you to. I think the best one is the Seventh Circuit's decision in the CTA case. Here, though, the question is, it doesn't have to be, they don't have to be trying to take the track itself. Every track in America has property on either side of it that is just as important as the track itself. Sometimes it's used for access, road access. Sometimes it's used to create sidings. But in this circumstance, it's there to provide for drainage. So if you don't have appropriate drainage for a rail bed, you're not going to have a rail line for very long. And so the record in this case established that this is in a 100-year flood zone. And so that Norfolk Southern 100 years ago made sure to acquire sufficient property on each side of the right-of-way so that they can control the flow of water. So you'd have no standing water above or on either side of the right-of-way. So they secured 75 feet, which, doesn't seem like a lot. As we say in the briefing, it's the distance to less than the distance to third base. But it's there for a purpose. And it's clear that permitting a property owner to forcefully remove that property from the interstate rail network would require Norfolk Southern to change its operations. It would have to find a different way to control the flood zone. And so I'd say that those factors together should be sufficient to satisfy the complete preemption doctrine. You would then
Counsel, let me ask you, if the plaintiffs here made an application to the STB for the damage to their property, their adverse possession claim, would the railroad take the position that they were not considering the merits, but take the position that they were barred from making the application?
It's possible, Your Honor. So I just want to be very transparent. It depends entirely on the relief that they ask for at the STB. So the relief that's available under federal law for a adverse possession type claim, which is the claim that we think creates jurisdiction, is different than what's available under federal law. So you cannot go to the STB and ask the STB for an order to declare that this property belongs to the plaintiff under any theory under the Interstate Commerce Act. That issue actually went to the STB after a case was removed out of state court to federal court under the complete preemption doctrine. That adverse possession claim was referred to the STB. The STB said that that relief doesn't exist. So those are just kind of the facts I've got to deal with. But I don't think that, Your Honor, defeats the complete preemption doctrine because, again, the Supreme Court has said that the remedies can be different. So in one of the cases at the Supreme Court, the remedy that they wanted in state court was an injunction to stop a labor strike. This is the very first complete preemption case. It went up to the Supreme Court. The Supreme Court said that it satisfies the complete preemption doctrine, so it was appropriate to remove it into federal court. But they observed that the injunction wasn't available. It's an unavailable remedy under federal law, or I think actually the lower court said that, and the Supreme Court just declined to rule on the issue because they said it didn't matter. It didn't matter to the question of jurisdiction because the remedies can be different. And here, Your Honor, there's no question the remedies are not the same. However, if they do go to the STB and they secure an order, now that property is no longer within the interstate rail network. Now all of the state claims, tort claims, state regulation, everything can apply with full force to that piece of property. But until they actually remove this property from the interstate rail network, and the only way to remove it is through the federal regulatory agency, this type of cause of action is categorically or expressly preempted. And I would submit, Your Honor, that it falls sufficiently within the scope of the Interstate Commerce Act to satisfy the complete preemption doctrine.
So it's your view that if the plaintiffs or someone similarly situated went to the Surface Transportation Board and asked that in this case, the property on their side of the creek were released from the railroad corridor, they could then proceed against Norfolk Southern in state court to make an adverse possession claim. Is that where it comes out?
Yes, Your Honor. I believe that's right. Now, whether they could win in state court under state law, I have no idea. But so long as the federal sort of umbrella of protection for the rail corridor exists, a adverse possession claim simply doesn't exist. It gets subsumed by federal law, and you need an order from the STB to remove that protection. You need an STB order compelling the property to be removed out of the interstate rail network. Otherwise, that is a state law that is unequivocally regulating rail transportation, because what it's saying is you may no longer use this property for rail service. It's no different.
Mr. Atkins, can I follow up on that?
Absolutely.
But the statute in this case, the relevant statute provides jurisdiction both to the STB and to federal courts. So why couldn't the district court make that initial declaration as to whether or not the land lies within or without the corridor?
That's a good question, Your Honor. So there's no question that the district court can rule on the preemption question, whether or not it falls in or without. I would submit, Your Honor, this though would fall under the primary jurisdiction doctrine. So the primary jurisdiction doctrine is in place for this type of circumstance where, although the district court has jurisdiction to entertain the questions arising under the Interstate Commerce Act, that there is a judicial sort of prudence consideration where you really want to direct that inquiry to the agency that has the competent expertise. If the district court referred the issue to the STB, it still has jurisdiction over the case. The STB's decision then goes back to the district court, who sits as in an appellate role and reviews the STB's decision. So I think that would be the appropriate recourse. If somebody wanted to bring that type of claim in federal district court, I think it would immediately get referred to the STB under that doctrine. And honestly, I think it might be an abuse of discretion for a district court not to refer that type of question to the federal agency.
So what are we supposed to do in this case? Isn't that what should happen here?
So the ordinary course in these type of cases is when the state law claim is preempted, you pull it up and you just say it's preempted, and then you look to see if the other causes of action survive. This is not a dismissal with prejudice to bring some sort of action before the STB. It's not a dismissal with prejudice to bring some other federal claim that might be permissible under the Interstate Commerce Act. It's just a question of, is this state law claim preempted, which it is, whole series of cases finding that it's preempted, and then do any of the other claims survive once it's clear that they don't have a property interest in the property that they're claiming is damaged. And the district court, I think, appropriately ruled that the majority of those claims were dismissed on mootness grounds, and then the only claim that the district court looked at a little more carefully, even if they don't own the property in question, the bank itself that's eroding, might there be a claim under West Virginia law that the railroad still needs to take into consideration the property that they do own? And in that case, the district court said there just weren't enough facts alleged in the complaint to survive a motion to dismiss. So I think the appropriate recourse here, Your Honor, is to affirm, uphold the important federal jurisdiction question about complete preemption. And then once you agree that or if you agree that this type of adverse possession claim, it cannot proceed under state law, I mean, that is granted, then I think the rest of the case naturally goes the way the district court did it.
The reason I asked that is because we have some authority in the
sorry.
Go ahead, Judge Agee. I'm sorry. Go ahead.
No, I was going to ask in this circumstance if we agreed with you, and then the plaintiff came back with a separate proceeding in federal court and asked under the statute that their side of the creek be abandoned or removed from the rail network. And either the district court make that decision or refer it to the SDB, would the railroad take the position that they are either collaterally estopped or barred by res judicata from bringing such a claim?
That's a really good question, Your Honor. I hesitate to take a position on that.
I hope you have a really good answer.
It's possible that we might argue that they should be estopped because it was a cause. It was something they could have put into the complaint. They chose not to. But I feel like I just can't take a position. I hadn't thought that through carefully enough, Your Honor, to know if that would or would not be. But I don't think it affects the fundamental question of jurisdiction. Did the district court have jurisdiction for removal purposes? And I think the answer there is reasonably clear.
To follow up on Judge Agee's question, so we have some authority in the context of ERISA where we have indicated to federal district court judges that even when a claim is completely preempted under ERISA, that the district court judge's obligation at that point, or at least a suggestion, is that he or she should take the initiative to convert the claim into the proper federal proper claim that would apply under the relevant statute. So why wouldn't we simply send this case back to the district court and say, convert this claim into this, cause of action that lies appropriately under the statute, and decide whether you, or in the first instance, the Surface Transportation Board, should decide the matter?
Your Honor, I would just suggest that should have been incumbent on the plaintiff, not on the district court. So although I'm not familiar with that line of precedent, so maybe you have ruled that even if it was never presented to the district court, they still had an independent obligation. But I think here, like the Elam case, which was on a very similar footing, there was no suggestion at the district court level that a referral to the SDB was sought by the plaintiff, that they sought to actually seek an abandonment, which, Your Honor, would be wise on their part, because the standard for granting that under the Interstate Commerce Act is very high, very unlikely that they would actually satisfy it. So they wanted to pursue just their claim under adverse possession. And I don't necessarily think it would be an abuse of discretion on the district court's part not to have transformed it into a claim they weren't asking for, or to make a referral that wasn't sought. So I would just argue, in these circumstances, maybe you could give guidance to future applicants, but to suggest that the district court erred by not referring a matter to the STB when they weren't asked to be referred, or to create a new federal cause of action that was not, the plaintiffs did not try to pursue, I don't think would be appropriate in these circumstances.
I would imagine that that the situation we face here could become a fairly commonplace one. As I mentioned earlier, the railroad's interest under the statute don't begin and end between the two rails. And there are going to be a lot of situations where the railroad has essentially done nothing and hasn't improved the property. And the things they may be important to railroad operations, but things have laid basically dormant over a long period of time. And then so it's almost ripe for a claim of abandonment, because these properties are often going to be near the property line of the plaintiff, and they're also going to be near the auxiliary activities that a railroad needs to run. And so you have this thing that's sort of in the borderland in a way, and there may not have been a great degree of activity or improvement for a prolonged period of time. And so I think that there could be an awful lot of adverse possession claims. This strikes me as a fairly, if we held that it was not completely preempted, I wonder if we'd be opening the door to a great many claims of this nature, and whether that would be in tension with the basic aims of the statute.
Yes, Your Honor. So I see my time has expired. If I have your permission to answer the question.
Yeah, please.
I couldn't agree with you more. Just if you take a step back, Norfolk Southern operates 20,000 miles in the eastern half of the United States. And they would die a death by 1,000 cuts if every property owner who abutted those rail lines could simply carve away slivers and slivers of the rail corridor, which is why the STB, when it looked at this issue very carefully in the GL case, it really spoke to the importance that the Congress placed on preserving these rail corridors, not just the entire line, but also the slivers on either side of it. And it set a very high bar for forcing the removal or permitting these types of claims to go forward, because the STB is not just concerned about the present use of that property, but the future use of that property. So, we have seen the STB say that an attempt to condemn or use adverse possession of even a rail bank line is preempted.
Well, I'm just thinking, my personal experience, I ride Amtrak a good bit of the time, and one of the nice things about it is it has a pretty wide window, and even in short runs between Charlottesville and Washington or whatever, I'm amazed at the number of pieces of property of all descriptions that fly by. And the layout of the land is somewhat like it is here. There's a sort of unimproved parcel of land that marks the sort of boundaries between the railroad's operations and the property, and the property behind it. And very often it may be swampland, or it may be just land that maybe land is not put to any particular use, but there's a great deal of that. And I think if each one of those properties that I drive by, or that the train drives by, is going to be the subject of an adverse possession action, and the claim is going to be that because the railroad hasn't improved it or isn't using it in a highly visible way, that somehow it's relinquished its right to the property. The multiplicity of the claims would be staggering, and they would be resolved in a forum in which the dynamic is completely adverse to the railroad and to our national transportation structure, it could be just chewed up by this kind of thing. And that's the very thing that I think the statute was passed to avoid, this kind of thing. But I mean, there's a lot of danger lurking here in the potential for litigation in a forum that I think the railroad would find itself at a very distinct disadvantage, because the decision makers in the case can tend to look, not in all cases, but in many cases, can place a priority upon parochial concerns. And I think that's what Congress, one of the things Congress wanted to head off. And so that, you know, that's my concern. You understand what I'm saying?
Absolutely, Your Honor. And why don't I then just end my remarks here by referring back to the actual legislative history behind ICTA, because it confirms exactly what you're saying. If you read the legislative history, I think there's two things that are of interest, should be of interest to the court. One is the obvious overarching interest in centralizing the regulation of the railroads at this federal agency. But also, in the House report, the Congress actually spoke of their desire to, quote, completely preempt, quote, state law. So I really do, I agree with you completely, Judge Wilkinson. You would have you'd be opening up floodgates of claims being brought in the wrong forum if you were to conclude that this type of cause doesn't fall sufficiently within the Interstate Commerce Act to accord with what is Congress's intent, which is to centralize the decision-making at the federal level and completely preempt these type of state law claims. If there are no further questions from the court, I appreciate the extra time and we'll await your decision.
All right, if there are no further questions, I'll thank Mr. Atkins and ask Mr. Foster if he would come up and give his rebuttal argument.
Thank you, Your Honor. And first, I'd like to respond to your concerns. They are valid concerns, and I agree 100% with the policy considerations, and those are taken care of by ordinary preemption doctrines. The U.S. Supreme Court has been very specific in stating that federalism concerns must be carefully addressed. You know, this court said if a statute includes an express preemption, then it implies that things beyond that express preemption are not preempted. In this case, there is an express preemption clause within the relevant statute, and it does not address any of these things like keeping the corridors open. So the real test for complete preemption is, what did Congress intend for this statute to do? And we do that by looking at how is it written. And it makes no comments whatsoever with regard to, hey, we need to keep property all together. We can't allow pieces to be carved off here and there. There's a separate tool for that, and that's the ordinary preemption doctrines. With regard to subject matter jurisdiction, we are constrained by the statute itself. What is the statute designed to protect and prevent? It's designed to protect federal control over economic regulation of rail transportation, not every state law that could ever possibly touch on rail operations. So I think any reading that would subsume all state laws in this case would expand too far beyond the permissible bounds of what Congress intended. And remember, this court's jurisdiction must be construed narrowly. And if there's a reasonable, plausible basis for it to remain in state court, it should remain there. And I want to go.
Well, but there are a number of cases out there that take this term. You know, the whole question is, what does regulation mean? And there have been a number of cases that have equated regulation with interference. And it's hard to see that a claim that could interfere with the railroad's interest in drainage with its tracks, and I can't imagine an interest that is more vital to rail transportation than drainage of its tracks. You let water fester around there. You really really jam things up. And there are a number of cases, I think a good many of them, that have equated the term regulation with interference. And the question I have is a state cause of action for adverse possession. That can be regulatory in the broadest sense. Doesn't have to be a formal reg. Regulation can come through a common law cause of action that would interfere in the most basic way with the operations of a railroad. We're not talking about some marginal or ancillary function of the railroad. We're talking about drainage, which is absolutely critical to the maintenance of the tracks. And
Your Honor, if I may, I see my time is running down, but
go ahead.
We're not saying that Norfolk Southern can't drain its tracks. All we're saying is it can't drain its tracks in a way that damages an adjoining landowner's property. And the 10th Circuit has addressed that case. And the 10th Circuit has held in the Emerson versus Kansas City Railway case that a railroad company is just like any other landowner and has to manage its runoff like any other landowner. There's a perfectly feasible way to do this. The drainage pipe actually runs underneath the rail lines. We're not even saying they have to move the pipe. All we're saying is that the way that the pipe is currently installed is damaging our property. And if I may go
well, but this is different from the kind of dispute between two neighbors where, you have adjoining pieces of property between homeowner A and homeowner B, and they fight over drainage between those two properties. This is a national railroad network where if there are drainage problems in one section of the overall transportation and they're left to fester, then that affects the whole. The part affects the whole in this context to a much greater degree than the typical adverse possession action. Most of the adverse possession actions that I have come across have dealt with a fairly discrete property dispute between adjoining householders, and very few of them have arisen in this context, which is an assertion of control over a vital function of transportation, which, as I mentioned earlier, is part of the whole. And that context of this adverse possession action is very different from the ordinary adverse possession action that we have come to think of through our real property classes. And it's that difference in context, it seems to me, that makes this particular common law cause of action an interference of a basic nature, and it regulates railroad operations as much as any statute or regulation ever could. And this is what I am concerned about, and it's just different from your ordinary real property dispute, and not just difference in degree, it's really different in kind. And but I want to give my colleagues a chance to answer ask their questions, and I also want to give you your argument, and I want to give you the last word. So you go ahead, Mr. Foster.
Mr. Foster, one question. Opposing counsel seemed to acknowledge the possibility, without making any commitment on behalf of his client, that either you could in the future, if you're unsuccessful here, or could have, perhaps by amendment in the district court, have brought a separate claim to have this property removed from the rail network, and either have the district court consider that in the first instance or transfer it to the STB, in effect as a condition precedent to making a claim in the state court if the property were removed. Is that something that you have considered previously, or have a reason not to consider in the future if you were unsuccessful here?
Your Honor, I certainly appreciate the question, and I was caught a little off guard by the argument because it appeared nowhere in the briefs, and I'm hearing it for the first time today. What I heard during the briefing was that we could have brought our claim.
Well, in fairness, counsel was responding to our questions, I think.
Well, Your Honor, and I'm getting back to my supplemental authorities letter. In response to my supplemental authorities letter, they cited to a statute that they just heard oral argument agreed has no applicability, and then referred to, I believe he stated that the STB has crafted another mechanism for things that don't fall within the only statute which he referred me to. So there's no citation to this other mechanism that the Surface Transportation Board has crafted. So I did not see anything during my review when I was drafting the complaint. Right now, standing here, I don't know what the elements of this STB crafted mechanism is. I don't know if I can meet it. I can tell you, Your Honor, that I will exhaustively look through every potential avenue, state and federal, to get justice for my client. But I do want to go back to the Lance case that says the federal cause of action must appear in the statute. It doesn't say, hey, go take a look at the STB and see what special mechanisms they may have created by decision. It says, hey, pull up the statute. What does the statute say? And in this case, the statute talks directly to economic regulation and doesn't touch on these matters. But Your Honor, to the extent that if there is an adverse decision in this case against my client, I will certainly do my best to find whatever mechanism Norfolk Southern's counsel is referring to here today. But it does not appear anywhere in the ICCTA as required under U.S. Supreme Court and this court's precedent in order to make a finding for the complete preemption doctrine to apply.
All right, we thank you, sir. And
I'm sorry, Judge Wilkinson, you had a question on the table. If I just may respond to it, you were with regard to drainage being a part of rail transportation. And again, I appreciate the time I've been granted, but just a very quick point, if I may, sir.
Yes, Mr. Foster, I'd be happy to hear from you.
49 USC section 10102 contains the definitions section for the ICCTA. Subsection 6 relates to railroads, and railroads include a bridge, car, float, lighter, ferry, and intermodal equipment used by or in connection with the railroad. Subsection B, the road used by a rail carrier and owned by it or operated under an agreement. And C, a switch, spur, track, terminal facility, and a freight depot, yard, and ground used for or necessary for transportation. And transportation is defined under Section 9 as including a locomotive, car, vehicle, vessel, warehouse, wharf, pier, and I won't read the entire thing, but it goes on and states subsection B, services related to that movement. including receipt, delivery, elevation, transfer and transit, refrigeration, icing, ventilation, storage, handling, and interchange of passengers and property. No mention of drainage anywhere in the definition section, Your Honor. That is a function of a railroad operator that it applies to every business, whether you're interstate commerce or not. Railroads are required to manage their surface water like any other property owner. That is not a concern of the ICCTA. It does not appear in the statute and should not be part of the court's consideration of whether or not the complete preemption doctrine applies in this case.
All right, Mr. Foster, I appreciate your argument. Judge Agee, do you have further questions?
No, sir. Thank you.
Judge Diaz?
I do not. Thank you.
Okay. Mr. Foster and Mr. Atkins, thank you both for your arguments. I'm sorry, as I mentioned in the last case, that we can't come down and shake hands, but we very much appreciate the presentations that you've made, your service to your clients and to the court. Thank you both.
Thank you, Your Honors.
Thank you, Your Honor.
All right, I'll ask the courtroom deputy